This appeal arises out of a suit filed by the appellant herein for declaration of his title to and possession of a small extent of property from the respondent herein and for injunctions both permanent and mandatory stop. The appellant and the respondent are adjacent owners of the land, the appellant being the owner of the northern portion and the respondent being the owner of the southern portion stop. The case of the appellant was that in or about June 1962, the respondent encroached upon a portion of his property by shifting his stone ridged towards the north stop. As soon as he came to know of the encroachment, he moved the revenue department and requested the officials to effect measurement of the boundary line, and accordingly the boundary line was measured in November 1962 stop. The encroachment made by the respondent was made known to him stop. As the respondent did not remove the encroachment and surrender the encroached portion to the appellant when requested to do so by him, the appellant instituted the suit stop. The respondent's case was that the disputed property did not belong either to the appellant or to the respondent but belonged to the government, and the respondent did not encroach northwards by shifting the stone revetment as alleged by the appellant stop. The learned district munsif found that the disputed portion belonged to the appellant and the respondent had encroached upon an extent of 1/2% of land belonging to the appellant by shifting his stone ridged towards the north in or about June 1962, and therefore the appellant was entitled to a decree declaring his title to the suit property and a permanent injunction restraining the respondent from in any manner interfering with the appellant's possession and enjoyment of the same, and also a mandatory injunction directing the respondent to remove the stone wall put up by him on an extent of 1/2% of land and surrendered possession of the same to the appellant within a period of 1 month, failing which the appellant would be at liberty to have the said encroachment removed through court at the respondent's expense stop. Against this judgment and decree of the learned district munsif, the respondent preferred an appeal, and the same was deposed of by the learned additional subordinate judge of Slim stop. The learned additional subordinate judge agreed with the conclusion of the learned district munsif that the disputed property belonged to the appellant and the respondent encroached upon an extent 1/2 cents in the land belonging to the appellant herein stop.